What's the most important estate planning document you can have? Now, most people will answer, well, a will, of course. That says where my assets go when I die. And there's a lot of validity to that. Having a will that directs your assets when you die is important, no doubt. But I want to talk about what I refer to as living documents. Why do I think that those are more important than having a will? Well, the reason for that is I call them living documents because these are documents, estate planning documents, that are in place while you are alive. So you haven't passed away, but perhaps you've been in a car accident and because of your injuries, you're not able to speak, process information, talk to your doctors, earn a living, manage your bills. You just are not the capable person you were before that car accident. It doesn't have to be a car accident. Commonly we see strokes, dementia. There's all sorts of reasons that people move from being independent to being dependent and unable to make their own decisions. What happens if you don't have important living documents in place? If you don't have the necessary living documents, those are your durable power of attorney for finances and your durable power of attorney for health care. You haven't designated anybody with the legal authority to speak on your behalf. So who is going to speak on your behalf? That is going to be a guardian or conservator, as it's known in different states. Who is that person? It may be somebody you have never met before, because since you've lost the legal ability to manage your own decisions, and because you don't have these critically important living documents called durable powers of attorney, the state must step in through a court-ordered guardianship or conservatorship. They will appoint somebody who you may know. It might be a family member, it might be your spouse, or it could be somebody who you have never met before. It's called a professional certified guardian, a certified professional guardian, and they will be making all the decisions for you based on what they think you would do, but it's still somebody else, not you, or not somebody you would have wanted. You would have appointed had you thought through it to say, should I have durable powers of attorney? Absolutely yes. Most important documents you can have are your durable powers of attorney so that you keep the state, the court out of your business. And you heard me say state and court. That means all those expenses related to the guardianship are going to be paid from your money, and it's going to be far more expensive than had you appointed somebody through your durable powers of attorney. Not only is it more expensive, more complex, court reporting, court permission, it is very intrusive into your life. Whenever the court is monitoring actions, bill paying, personal care plan, that is all in front of the court, in front of a judge or a court commissioner to give approval for things, which probably is not what you want. You would probably prefer that you appoint a trusted person, a loved one, a friend, a family member who knows you, who can manage your affairs for you, and not the court. So the most important estate planning document you can have during your lifetime is your durable power of attorney for finances and for health.